Welcome to the last talks of this academic year. The next talk will be in September. September 6th is what we're projecting will be the next talks. These talks happen typically when we have school in session, although in the summer it's probably better to take a month off and let people triage between the beauty of the summer and the work that they have to do. In any case, you have microphones in front of you, and so if you rather your keys, we will hear them on the recording. There's a legacy recording being made that you can go to CMU Silicon Valley and see all of the TOCS talks. There are about 80 of them. And they've been from all sorts of fabulous people from all the major universities and the best startups you can think of, and national research laboratories, and of some very famous and exciting people. Today, we have Kanda Ishihara, and she's going to speak about intellectual property. It's a very interesting topic because, in fact, it circumscribes lots of the behavior that people get themselves involved with, what they'll talk about, what they won't talk about, what they'll do, what they won't do. Very, very gating factor. And yet, it's vague to many people. And we like to, we all know that forgetting about the intellectual property is the only way to have a real conversation between people. And so, how do we do that is one question. But I think today we're going to talk about how do we create and what is intellectual property, if I understand it. And so we really appreciate having you here. And you have until about 2:20, 2:25. And at that point, we want to make sure that we get some questions in, and then we go out in the hall and people can have a few minutes to have some sodas and cookies with you as well. So thank you for coming.
Thanks, Ted, for that introduction. I'm actually very excited to be here today. I am a practicing patent attorney at Patent Law Works, which is an IP boutique law firm, and we're based out of Salt Lake City, Utah. And for those of you who don't know what an IP boutique law firm is, it's basically a law firm that specializes only in intellectual property. So that includes patents, trademarks, and copyrights. So we don't provide any legal counsel with regard to other areas of law, such as employment law, or real estate, or family law, etc. We do have an office in Palo Alto, and the reason for that is majority of our clients are here in Silicon Valley. The title of my talk is Patent Essentials for High Technology Companies. So I'm assuming here that you do not have any knowledge with regard to patents. So I'm going to walk you through the basics and then provide also a little bit of insight into why an employee of a high-tech company would be interested in patents. So let's just start off with the overview of the talk. I'll talk about why get patents, what actually is a patent, who is entitled to a patent. I'll walk through the legal standards of a patent, and also go through a little bit about the patent process. So if at any time during the presentation, if you have any questions or comments, please feel free to interrupt me. Hopefully, as Ted said, we'll have some time for discussion and questions at the end. So let's first talk about why you would want to get a patent. What does having a patent entitle you to do? Well, first, if you have an invention and you have a patent for that invention, and you see someone infringing your invention, you take them to court. You bring it into litigation. In litigation, you could ask for an injunction. You could ask them to stop practicing what you have invented. And if you're successful in that litigation, you can be entitled to damages. You can be entitled to reasonable royalties. Money that you would have received had that person gotten your permission to practice that invention. And also, if you are successful, you can also get what's called treble damages, which are triple damages that act to punish a willful infringer. So someone who knows that your patent is there and willfully infringes upon your patent. The court can grant triple damages to punish that willful infringer. So another thing you can do with a patent, which is most commonly done for patents, are you just license it. And license it means that you give someone, another party, permission to practice your invention in exchange for money, in exchange for royalties, for that permission to practice your invention. You could also do what's called cross-licensing. You can give that person a license in exchange for a license to do that party's invention. So that's called a cross-license. So you can license it out for money, and you can also license it out in exchange for another license. You could also do nothing with a patent. There's no legal requirement to actually use a patented invention. I used to work with an inventor who was a very, very prolific inventor. He had over 200 patents to his name, where he was the lead inventor for those 200 patents. And many of the patents he licensed out to companies, and he made some money off of it. But a lot of those patents he just basically framed and hung up on his wall, just to emphasize that there's no legal requirement to do anything once you are granted a patent. So what is the definition of a patent? What is a patent? A patent is actually a legal document that sets forth an explanation of how to make or use the invention. So you're telling, publicly disclosing how you're making and using the invention in exchange for unlimited monopoly to make or use or sell that invention. That's kind of the basic definition of a patent, is actually a legal document. But what are patent rights? Now, what are the rights that you can obtain from having a patent? Now, patent rights are not necessarily the right to practice your invention. It doesn't necessarily give you the right to make, use, or sell your invention. It's actually the right to exclude others, to stop others from making, using, selling, offering to sell, or importing your invention. So, I mean, to illustrate that in an example, if we have a pen, and this pen is already patented, it's got an active patent by an inventor, and another inventor comes along and makes an improvement upon the pen. So say he adds a special eraser, or he adds some sort of special click feature to the pen. That inventor actually does not have the legal right to make the improvement, the improved pen, without first getting the permission from the original inventor of the original pen, because that original inventor has the right to stop others from making his invented product. The inventor of the improved product first needs to get permission from the inventor of the pen product, the original pen product, in order to make the improved product. And at the same time, the inventor of the improved product can stop others from making, using, selling, offering to sell, or importing his improved pen. So the emphasis again is it's not necessarily the right to practice the invention. It's the right to exclude others from making, selling, using, offering for sale, importing your invention. It's the right to stop others from doing that. And there's no requirement to license it. So once you get a patent, there's no legal requirement for you to actually give other people permission to practice your invention. There's no legal requirement to do that. So are there any questions up until this point? It's kind of pretty basic background knowledge. So, yes?
What does it cost to get and maintain a patent?
It's very expensive. That's a good question. The cost could range. So the bulk of the work that's needed in order to write a patent application is all in the very beginning. It's all in drafting and I'll go into a little bit more about the components and why it's such a lengthy process to actually prepare the patent application. It can cost tens of thousands of dollars to actually prepare a patent application to submit to the patent office. I mean, you could do it yourself. There's a lot of do-it-yourself books out there in order to, tell you how to prepare for one. But a majority of the cost is in preparing to file the application. And there's a fee associated, a fee that the patent office charges. It's about, I think if you file it, it's about $1,000. That's if you have 20 claims or less. But if you are a small entity, that fee is cut in half. So the point is the majority of the cost comes in the preparing of the application. And then there's fees associated with the prosecution of the application as it is being examined in the patent office. And there are fees once you get a patent granted to maintain that patent. And I'll talk a little bit more about that in the later slides. So once you have a patent, how long do your rights last? What is the term of your patent? So the patent term basically starts on the date that your patent was issued. So the date that the patent office grants you the right for the patent. The patent office grants or issues patents on Tuesdays. So you'll see every Tuesday comes up with a new list of new patents. And that term ends 20 years from the filing date, so the date that you filed your patent application. So just to illustrate in a timeline, and I'll talk a little bit more detail about this in some later slides, but I just wanted to illustrate the timeline with regard to the patent term. So you see here at month 0 is when you file your patent application. A couple years later, after the application has been examined from the patent office, and if you are successful in convincing the patent office that your invention is patentable, here it's illustrated at 40 months patent issues. So once it issues, that's when your patent rights start. But the term is calculated from the date in which you file the application. So if you're in that middle process from between month 0 to month 40, and you see that someone else is using your invention, you really have no rights against them because you only have a pending patent application in the United States. You don't have any patent rights quite yet. You can let them know that, yeah, you have a patent pending, but there's nothing you can really do at that point until the patent issues. So any questions on that? Yes.
So could they create a patent in that interim and file it after you and by some happenstance get this issued before you?
They could try, but as you'll see in the next slides, the person who's entitled to the patent is the inventor, and the inventor is the person who's actually invented it first. So theoretically, when you file the patent application, you are the inventor, even before you file the patent application. So they could try to file something, but as you'll see also in some subsequent slides, that there are certain situations that would stop them, the subsequent patent applicant, from obtaining patent rights. So was there a question online? No, I just saw some.
The person said it was first to file, not first.
Well, I'll see in the subsequent slides. In the United States, it's the first to invent, but in other countries, it's the first to file. So I'll go through that in a few slides. I think that's as of last week. So in Congress, I think it's up against it's been patent reform has been something that's always kind of been up every year, but I think it's something that we'll discuss in the later slides. So who is entitled to a patent? This is what we were talking about before. And this is something that's always kind of comes up in Congress in terms of the rest of the world has this first to file system, so it creates a rush to the patent office in terms of who is going to be deemed the inventor. But the United States has had this first to invent system. So even though you may not be the first person to actually file the patent application, if you can prove that you first invented the invention, then you will be deemed to be the inventor. Yes.
I believe there's a requirement for diligence.
Yes.
If you do not
Right.
know anything about it, then you lose that.
Right. So if you have this idea and you conceive of the idea, so there's a requirement of conception, and then there's also a requirement of reducing that what you've conceived to practice.
No, this is separate.
Right. And then, but if you say you need to be diligent in that you can conceive it and then say you walk away from it for a while and you don't do anything to it, that's what you're talking about. There's this duty to be diligent about it, to not kind of abandon it. So you can't just conceive of it, the idea, walk away from it for a while, and then come back and try to reduce it to practice. Then that kind of cancels, right, during that time period, it cancels your right as the inventor. So there's a requirement to conceive it, reduce it to practice within a reasonable amount of time.
What happens if you file in the United States as first to invent, somebody else files your idea everywhere else in the world as first to file?
Yeah, so it's so patent rights are specific to each country. So if you have a patent, if you're granted a patent on your invention in the United States, and you are, let's assume that you are the inventor, you're the person who successfully was awarded that patent in the United States, then that has no effect anywhere else in the world. So if other people have invented the same thing and apply for patents other places in the world, and you did not apply for patent protection in those places, then you do not have any rights in those places. So your patent rights only extend to the country in which you are granted a patent application.
So is it very common for people to approach other people's patents and make foreign filing?
Probably. I mean, I haven't really come across a lot of that, but a lot of these inventions also are very complicated. There's very many steps, right? But yeah, there's since this first to file system is in the other countries, it's easier to kind of prove that you're the inventor by just simply filing an application in that country. So it's important to be on file as early as possible. And so in a first to invent type of system, then how do you prove that you're the first person to invent? It's important to keep written, detailed records. And some companies make it a practice to mandate their employees to keep these notebooks and also get the notebooks, each page initialed and dated so that there's more proof, more evidence of inventorship. So let's just get into the legal requirements for a patent. So you'll see on the left-hand side of the screen are the conceptual legal requirements. And on the right-hand screen is kind of the implementation, how you achieve those conceptual legal requirements. So let's just go through the conceptual requirements. United States Code Section 101 dictates that you have to have patentable subject matter. 101 also says that your invention needs to have utility. It needs to be useful in some way. United States Code 102 says that your invention has to be new. It has to have some sort of novelty. And also, it has to be non-obvious. And in the next subsequent slides, I'll go through in a little bit more detail as to the definition of these requirements. And in the implementation of these conceptual legal requirements is how do you achieve this? You need a written description, which it has enabling disclosure, and it sets forth a best mode. And the actual language in the United States Code, Section 112, states that the specification shall contain a written description of the invention and of the manner and process of making and using in full, concise, and exact terms to enable persons skilled in the art in which it pertains. So this is someone who we call person of ordinary skill in the art. This person is not a PhD who has a specialized expertise in a particular field. This person is actually, say, someone with a bachelor's degree with about 4 or 5 years experience working in the field. So that's the person we're talking about. To enable that person to make and use this invention, and it should also set forth the best mode of carrying out the invention. So that's kind of the written description requirement of a patent. Any questions on that? Yes.
If the patent attorney, if the patent office grants a patent, is it assumed that this has been done, or could you be granted a patent and then have someone later come back and say that's not a clear, concise description?
Yes, that's a very good question. And the answer is yes, it's assumed that these requirements have been met, but people could try to invalidate your patent. So people who maybe are making or using your invention, they look at the patent that has been granted and they see flaws in the patent. So that's where they would bring it to reexamination and try to invalidate your patent and say, hey, it doesn't meet the requirements of Section 112, and this is why. So yes, it's assumed that when the patent office grants your patent, these requirements have been met, but other parties could try to invalidate and prove that these requirements were not met. And if they are successful in proving that, then your patent is invalid.
So the requirement I'm specifically asking about is the clear, concise description. I mean, a lot of patents are kind of, from my non-expert opinion, they're sort of not really very easy to understand. So I'm wondering if the patent office, grants it, does that mean it is considered clear and concise?
Well, it also obviously depends on the circumstance, and you have to look at, you can't look at someone who doesn't have that skill in the art. You have to kind of step in the shoes of someone with ordinary skill in the art. So, there is some sort of examination that has to take place in order to answer that question. But, it's obviously it's not kind of a clear-cut yes or no type of thing, but you can, but once the patent office grants your patent, it's assumed that these requirements have been met. But if you can prove that the requirements actually haven't been met, and you actually maybe are missing the enablement part, where you outline different steps of how to make your invention, but you don't really describe and enable someone to actually do it. Then you say, okay, one of the steps is receiving data, but you don't describe, there's a special way you need to receive that data, and you don't describe how that data is to be received, then perhaps that doesn't fulfill this enabling requirement. Did you have a question on that?
My question is about the best mode.
Mm-hmm.
The best mode may depend on many things. For example, if there's a chemical process, it depends on the raw material you're putting in. What is the best mode?
Right.
So is there a single best mode, or can there be a best mode?
No, there doesn't necessarily need to be a single best mode, but it needs to be a best mode in terms of in the contemplated by the inventor. So a mode that's contemplated by the inventor that the inventor thinks is the best mode. But there is not one single answer to what the best mode is. Yes?
Are you going to talk about the phenomenon of wrongly granted patents?
I wasn't planning on it. But what do you mean by that?
Well, I guess that some patent examiners are insufficiently expert to assess the claims, and there are a lot of notorious cases of patents granted that shouldn't have been.
Yeah, I won't go through that in this presentation, but if you want to discuss it a little bit more offline, then I'll be glad to do so.
That's a general curiosity.
Yeah, and I'll go through a little bit about the patent process, and I have come across some examiners who are clearly not, shouldn't be the one who, examines the patent, and, some of these examiners won't even read the patent, they just go through the claims. But yeah, that's not something I was planning on talking about. But
the invalidity is the way that gets resolved, right? You can try to invalidate a patent.
Right.
And typically you wait until somebody's tried to exercise.
But unfortunately, it's difficult because usually the patent trolls go after smaller companies with their invalid patents.
Yeah. So I also mentioned there needs to be patentable subject matter. So the subject matter of your invention needs to be patentable. And patentable subject matter includes this list up here. Patentable subject matter is an apparatus, could be a machine. A machine is basically a device that performs some useful operation, basic machine. Patentable subject matter could also include a process, a method of making something, say a method of tempering glass to make it unbreakable, or a method of manipulating some sort of tangible object to become another object. That's a method. Sometimes software patents could be method subject matter. Also, what's included in patentable subject matter are articles of manufacture, consumer goods, compositions of matter is also patentable subject matter. So this is where the biopharmaceutical patents fall under, drugs and maybe formulas for different types of liquids or something like that. So that's compositions of matter. And any improvements upon these is all patentable subject matter. Yes?
So attempts to patent DNA of particular individuals, particular characteristics, where does that fall?
So
Composition of matter?
it would probably be composition matter. It all depends on, it's not, it's not an apparatus, it's not a process. Maybe if it's a process associated with manipulating, perhaps that, but it would fall under composition of matter. Yes.
And I assume you can mix a few of those different subjects.
Yes. So taking software as an example, you'll see later on the slides, the claims are what your invention is. The claims are what you are claiming to be in your invention. And as you mentioned, you can mix these. So for software, as I mentioned, software could fall under the realm of process or method, a method of searching for something, or a software method. But also claims could also be written as apparatus, so a system for doing something, which includes certain computer components or things like that. So just taking software application as an example, it can be written, the claims could be written to recite a method, and the claims could also be written to recite an apparatus. Okay.
And that would be the same patent?
That would be the same patent. If the steps highlighted point to the actual same invention, that would be the same patent. So some examples of unpatentable subject matter are scientific principles and pure mathematical algorithms. So my husband is one of the rocket scientists here at CMU. I found this yellow piece of paper lying around our house the other day, and as genius as this is, and as new as this might be, it's not patentable subject matter. It's a pure mathematical algorithm. So what are the types of patents that you can get? We've been talking about patentable subject matter, and all those things that we were talking about kind of fall under the realm of utility patents. These cover the way of using and making an invention. This is just your typical utility patent. Another another type of patent are design patents. Now, design patents are different than utility patents in that it only covers new and original ornamental features of an article of manufacture. So it just covers the aesthetics. If the design is particular in a way something is used, then that's not appropriate for a design patent. The design patent only covers the ornamental aspect of it, the aesthetic aspect of it. You could also get a patent for asexually reproducible plants. So inventors who asexually reproduce new plant varieties can possibly obtain plant patents. And the definition of a plant is just kind of the typical ordinary definition of a plant. The plant living organism includes algae and fungi, but it doesn't include bacteria. Another type of patent, some of you may have heard of that, is a provisional patent. So a provisional patent is basically a placeholder patent. It lets you obtain an earlier filing date that you may not have gotten if you're trying to prepare a full utility application. This provisional patent application system was designed to provide a lower cost ability to apply for inventions. The filing fees are lower. The requirements are not as, there's not as many requirements in a provisional patent application as there are for utility applications. You don't need any claims in a provisional patent application. It's merely just a placeholder. It lets you get something on file sooner rather than later. It doesn't get examined or prosecuted at all in the patent office. It just sits there. It doesn't get published. It gives you a year to file a non-provisional patent application that would claim the benefit of the filing date of the provisional application. And it automatically, if you don't do anything with it, it automatically expires and gets abandoned after 1 year from the filing date. Another type of application is what's called a PCT application. And this basically is a tool that helps to unify the application process for foreign filing. Foreign filing including countries that are contracting states with this patent cooperation treaty. It's a treaty that was concluded in, I think, 1970. Right now, as of June 1st, I think there are about 144 PCT contracting countries. So you can file a PCT application, which, similar to a provisional application, is a placeholder application. But the PCT application lasts 18 months, and before that 18 months is up, you can file patent applications in any of the PCT contracting countries. And then also you can get patent applications, obviously, in other countries as well. Yes?
The provisional patent, you're saying it's not published, so it can't be poached?
Yeah, it's not published.
So how are provisional patents poached by other people? How does that occur? I've heard that's a possibility with provisional patents.
Well, maybe if there's some sort of leak, aside from filing a provisional patent application, but it's not published in any way. It just stays within the patent office. It's not even examined, so it's possibly not even read at all. Maybe the poaching comes into play with just leaks with regard to the technology before it launches.
Not because of the provisional patent?
No. Yeah, I don't think so. So I talked about, this is pretty self-explanatory. Your invention needs to be novel. It needs to be new. It must be new at the time of discovery by the original inventor. It cannot have been done before. That's the novelty requirement. Now, the non-obvious requirement is, you ask this question. Given the prior art, and so for those of you who don't really know what prior art is, it's basically all the information that exists before you file your patent application. So this information, and of course it's all relevant to your invention. So the prior art could be other patents, other published applications of patents. It could be things that are found on websites. It could be journal articles, anything that's public knowledge, or anything that exists that's relevant to the patentability of your invention before you file your application is considered prior art. So given the prior art at the time of the invention, the question is, would a typical engineer, and as I mentioned before, the typical engineer is, someone with a bachelor's with about 4 or 5 years experience, would that person perceive the problem and come up with the solution and solve it with your invention without undue experimentation? So if the answer is yes to that question, then your patent is obvious and you don't fulfill this non-obviousness requirement. So in order, one of the requirements to be able to have a patent granted is it needs to be non-obvious. Any questions so far? Nope.
Just thinking of KSR.
Oh, do you want to go into that or? Okay. So let's just talk about patentability. And even if something is patentable, even if it's new, even if it's non-obvious, there could be things that bar you, that stop you from obtaining a patent. And so what are those things? If you publicly disclose or use your invention more than 1 year before you filed your application, then that could stop you from obtaining patent rights for your invention. So, once you disclose it, once you write about it in a journal article, or once you maybe give a talk about it in some conference, you have 1 year from that date to file a patent application in the United States. Other countries have different requirements, which I will talk about in a couple of later slides. But in the United States, you have this 1 year grace period from when you publicly disclose or use your invention to file a patent on it. Of course, the safe thing is to file your application before you publicly disclose, right? Because someone else could hear your invention, or hear your talk and go ahead and try to file that in the patent office.
So is selling kind of a single instance of say a product to a customer public disclosure?
Yeah, so that's what I'm going to talk about in this slide. It's sale and offer to sell is another thing that could stop you from, that could prevent you from obtaining patent rights. So if you offer to sell or sell your invention more than a year before you file an application for that, then that could prevent you from obtaining patent rights. And sale and offer for sale, even if it's under a confidential agreement, under an NDA, that still is included in a sale or offer to sell. There's a case where an inventor disclosed his application in an RFP, a request for proposal, and it was determined that that RFP was an offer for sale. So if you disclose your invention in an RFP, you have only 1 year from that offer to sell to file a patent application. And this is only in the United States, because as you'll see in other countries, there's an absolute novelty requirement, which means if you publicly disclose or use your invention, you are barred from obtaining patent rights in other countries. So it's important. We work with a lot of clients that have launch products, right? So maybe in the beginning they don't really haven't really determined whether or not they want to file this in other countries, the safest thing to do is make sure you file a patent application before you launch your product. Because if you launch it and then try to file it later, that could bar you from obtaining patent rights in other countries. Is there any other questions? So I talked about this before.
Is all of this based on the thought that this is an inducement to disclose? So if you disclose anyway, you lose any inducement.
What do you mean by that?
Well, you get the patent in order. It's given to you in order that you should disclose this for the benefit of the world. And
right.
So if you disclose beforehand, there's no need to get the patent from the point of view of you getting the incentive.
Right, because you've already kind of made that requirement to tell everyone about your invention, right?
So you don't need to give you any benefit.
You still have copyright and
yes.
And what do you call it? Keeping it to yourself.
Trade secret, yeah. So, but once you disclose it, though, all your trade secrets rights have been lost. So if Coke publishes their formula for their secret, their secret formula, then all their trade secret rights have been lost.
If they publish.
Yeah, if they publish
But
it.
they can be selling it for 100 years.
Right, and that's what they've been doing, right?
Now, if somebody steals it and publishes it, do they lose their rights?
So if someone steals it and publishes it, that person could be subject to, the consequences of doing that. But yes, the owner of that trade secret loses their rights. So you can't retract it. But so you have to. So if you want to keep your idea as a trade secret, it's very, very important to keep that a secret, because if someone divulges that person may, suffer the consequences of doing that, but you have lost your rights to that trade secret and can't take it back. And what you mentioned about copyright, you still have that, but that normally typically covers works of authorship, and it only covers the expression and not the idea. So the exact expression, of a book, but the idea of, say, girl from one family falls in love with boy from another side, another family. The expression and the actual, book is copyrighted, but the idea is not. So that's why you see different variations of the same type of story, right?
But you do find many people protecting their software products with
Copyright, right? Successfully.
Yeah.
So this is just kind of another emphasis about the written description, the requirement that the specification shall have a written description and set forth a manner and process of making and using it to enable one of ordinary skill in the art to make the same and set forth the best mode. So those are kind of the legal requirements. I'll go through the components of the patent application now. So the patent application, as I mentioned, is a document. It's just a document that sets forth an explanation of how to make and use your invention. And there's certain components that are required in order to have a patent application. One of those being a background. So this is kind of where you set the stage in terms of what is the existing problem out there, and perhaps what are the shortcomings of the existing solutions. You kind of set the stage as to, why you came up with your invention. And practically speaking, I like to keep my backgrounds pretty short, so you don't want to put too much information in there that could be used against you later on when the patent office is examining your patent and trying to determine whether your invention is patentable. So kind of like to keep it short, maybe 2 or 3 paragraphs. The next component is the summary of the invention. It's a summary of how the invention solves a problem and the shortcomings of the prior art. It's just a recap or a short summary of what the invention is. It's exactly what it says. The next component are the drawings and a brief description of the drawings. So the brief description being like a one-sentence description of what the drawing is. For example, figure 1 is a block diagram illustrating the process of making cheese, something like that. Just a one-sentence description of your drawings for each drawing is the brief description of your drawings. And with that, you have your drawings, and your drawings show your invention. For example, for software patents, you could have the first drawing be a system overview. It's just a basic high-level system drawing of what your invention is. So say if it's a software, you might have some sort of network and some user devices and some servers that are performing the functionality of your invention. So that's the basic system overview figure. Then you'll have some more detailed drawings of the invention, going more into the functionality of the invention itself. You can have flow diagrams that show the steps of the functionality of your invention. And you could also have state diagrams that show the invention's operation. There's special considerations in terms of software applications. So software drawings can be depicted as just functional boxes that interact with one another. So these can be shown as modules, and you would talk about how, what the modules do and how the modules talk to each other. This means that you're not necessarily including your code for your software. So the more lengthy, the more detailed portion of your patent application is the detailed description of the invention. This details the invention, and it's described using the drawings. So you kind of use the drawings as the outline in terms of what you'll be talking about in the detailed description. And the detailed description will go through each drawing one by one and fully explain all the components in that figure and how those components function and how they interact with each other in order to make your invention. So what level of detail do you need in the detailed description? We're going back here to one of ordinary skill in the art, someone who has 4 to 5 years experience working in the field, allowing that person to look at your drawings and to look at your description and then be able to make your invention without undue experimentation. That's the level of detail that you need. So all of these aforementioned things that I've talked about encompass what we call the specification. And the specification, you only get one chance to include all the material that you need to include in your specification before you file your application. So once you file your patent application, you can't add new matter and try to, still claim the benefit of that filing date. You can go ahead and fix typographical errors that you might find later, but you can't include any new matter. So it's really important to make sure your specification has all the information that you'll need, and even some other, alternate embodiments of your invention. But what is at the heart of the patent application are the claims. The claims are the legal statement of what your invention is. So the claims are basically the metes and bounds of your invention. It defines whether your invention is a machine, a process, or an article of manufacture, or as we were talking about, kind of a combination of some of them. And it goes from the broadest concept to specific implementation, and it's numbered. Each claim is numbered, and it's arranged in a hierarchical fashion. So the most broadest independent claim first, and then dependent claims after that. And this is really what the definition of your invention is. And you'll see later in my later slide that you have the ability to amend your claims, to change your claims if the patent office finds that there's something that makes your claim not patentable. You have the ability to amend your claims, but you need to have had support in your specification for those amendments to the claims. So in your initial filing of your application, you want to kind of try to claim a little bit more than what you think you're entitled to, so a broader type claim. And then with the support in your specification, you can make that claim a little bit more specific. So here's just an example of what a claim looks like. So this is a claim. It's numbered. The first claim is the independent claim. The second one is a dependent claim. It's a computer method of determining time zone for a computing device. And I'm not going to go through each step, but each step is what we call, the claim limitations. And then you'll see the second claim depends on the first. So the first claim is broader than the second claim, and the second claim kind of adds an additional limitation to the first, making it a little bit more specific. Is there any questions on that? So I showed this a little bit before, but I just kind of want to go through sort of the timeline of the life of a patent. Let's just kind of quickly go through the top portion where, when you're working with a company, you'll get an invention disclosure sometime, obviously, before you file your patent application. We'll go and meet with inventors, and they'll tell us, a little bit about the background as to, what's the problem here that they're trying to solve, and they'll tell us, how they'll give us an explanation of, how to make their invention. We take that information and we draft up a patent application, which includes all of those components that I mentioned earlier. Once the document is ready, you'll file it with the patent office. At month 0, it's filed with the patent office. The application goes through an initial review by the Office of Initial Patent Examination. It'll just go through the formalities, making sure, say, you filed, the required fees, or if your drawings are legible, or if your specification says you have 4 drawings, did you include 4 drawings? Those types of things. Once it undergoes this initial examination, it'll get into the queue of a patent examiner. And depending on what your technology is, you might have a long wait until you actually receive something from the patent office with regard to a substantive review of your patent application. Typically now for software applications, there's about like a 4 to 5 year wait before you get your first office action from an examiner. And so once the patent examiner actually gets their hands on it, they do a review of the patent application. Hopefully they read it. Sometimes they can just jump through to the claims. They do a search of the prior art. Oftentimes they'll find some art that they think makes your invention not patentable. They'll issue what's called an office action. And in that office action, they'll tell you, why it is your claims are not patentable. You have the opportunity to respond to that office action and let the patent examiner know, no, you're actually wrong. This is why my claims are patentable. Or, you can have the opportunity to amend your claims. So you can kind of go through several rounds of that type of back and forth. And hopefully at the end, you will have convinced the patent office that your invention is patentable. And then you'll get a patent that issues. And after the patent issues, there's fees associated with that. There's, in between, if you're using a law firm to prosecute your patent, there's obviously attorney fees associated with that. Once your patent issues, you have to pay the issuance fees, but once during the life of the patent, during your patent term, you're also responsible for maintaining your patent and paying maintenance fees on your patent. So you have 3 maintenance fees, one at 3.5 years after issuance, one at 7.5 years, and one at 11.5 years. So that's just kind of an overview. Yes?
So a question about the international patents. It seemed like the strategy that would be best would be to first have verification that you invented it, maybe a provisional patent, and then file international, and then file U.S. Because the U.S. only depends on I mean, once you file it, I'm trying to keep it, I mean, how do you keep it from public view before the international patents? Is the other question.
Well, did you want to say something?
Just after you file the patent, it is not disclosed for 18 months.
Right. And you could also, so once you file, I should mention, once you file the patent application, 18 months after that, your patent application is published to the world. But you could also request that your patent application not be published. You can keep it secret. And a lot of times we work with the companies around here who like to keep their technology a secret. So with the filing of their application, they file a request to not publish the application. But with that, if you then file an international application, you would need to rescind that request to publish. So, but oftentimes you can file this request to not publish the application, but once you decide you want to file it internationally, you just rescind that request to publish and go ahead and file internationally. It's 2:25 right now. So I'll just go through and I think we talked about this before. Patents only provide you rights in the granting country. So if you have a patent in the United States, that does you no good in other countries. And there's different subject matter restrictions for different countries. So, you can get a software patent in the United States, but for example, in Europe, it might be a little bit more difficult to obtain a software patent because they have this inventive step requirement. So even though you're successful in obtaining a patent in the United States, that doesn't necessarily mean you'll be able to obtain that same patent in Europe. And so that patent in the US is only good for others who try to make, use, sell, offer to sell, import your invention in the United States. So it's specific to the country. So what do you give up on issuance? You basically give up your invention. You tell people that how to make and use your invention. Publication, as we mentioned, can occur as early as 18 months. You can intentionally destroy patentability by just disclosing it. So if you don't think something is patentable or you don't want someone to try to obtain patent rights on it, just disclose it. Put it up on your blog or write about it in a journal article. That intentionally destroys patentability. This slide just shows that you have some duty to disclose if you have knowledge of the patents of others. So once you submit a patent to the patent office, if you come across something that you think is material to patentability, you need to disclose that information to the patent office so they have all the information at hand to make a determination of patentability of your invention.
If you do not, will it invalidate your patent?
It could. Yes. Patent infringement. You look at the patent claims and you compare it against the product. You look at every single limitation of the claims, and when I showed that claim with all these different limitations, in order to infringe that claim, you have to satisfy every single limitation of the claim. As we all know, patent litigation is expensive, but you can deter others from making or using your invention by simply just having the patent and letting them know about it. It doesn't necessarily always need to go to litigation. So there's some obvious benefits to companies. Many companies have huge patent portfolios. A lot of companies, that's basically, the majority of their assets are their intellectual property. Some companies build intellectual property just so, they have a portfolio that they can sell. And there's also some benefits to employees at times. Sometimes employers will offer monetary incentives to cooperate in this patent process. So if you work for companies and the companies are really focused on getting a lot of IP out there, they'll provide monetary incentives so that you will, come up with new ideas and participate in this patent process. So I think we're running out of time, but if anyone has any other questions, I'm available to talk. Thank you for listening.
Great talk. And it's a very, very large topic, and it's hard to know sometimes where to be in this. But if people have specific questions, I'm sure you're going to be around for a few minutes. We'd like to move the conversation away from the podium out into the hallway. So please take your laptop and meet with people out there.
Okay, sure. Thanks.
You missed the part of the talk where I said if you rustle things around on your desk, everyone will be alerting everyone.
For business card?
Yes, I do.
Just one question. If you invented something and you don't do anything with it for a while, then does that invalidate someone else claiming the invention, or does that mean you invented and you didn't take action?
Mm-hmm.